Other news we're tracking for you this afternoon, the amended SA's corruption legislation will now mean both the private sector, and state-owned companies face consequences for failing to report corruption. This follows the introduction of the Judicial Matters Amendment Bill 15 of 2023, which is aimed at dealing with state capture corruption. The new 34A has been added into the Prevention and Combating of Corrupt Activities Act 12 of 2004, also known as PRECCA. Let's unpack the story. There's lots of technicalities in that introduction. Caomeron Dunstan-Smith is a partner at Herbert Freehills. Caomeron, it's great to talk to you. Thanks very much for coming onto the program. It's certainly the big election issue, isn't it? This issue around corruption and combating corruption.
Thanks, Michelle. Nice to talk to you. Yeah, I mean, this is I think a good development. This any enhancement to our corruption legislation is a good development. And as you say, it's a hot topic. It's been corruption has been a hot topic for a number of years. And this is another, I guess, layer that's been put into our legislation to try and combat corruption.
So there's a new offence now in this law, in this legislation, this piece of amended legislation, and it talks about the potential liability for associated persons when it comes to corruption. What's an associated person, Caomeron?
So yes, that technically has always been a possibility, that someone acting on behalf of someone else. So, for example, a corporate that has an intermediary acting on their behalf, a partner or a subsidiary or whatever it may be, an agent that they use in South Africa. It could be a foreign company that has an agent doing their bidding or representing them locally. It's always been a possibility that they could be that the liability could be attributed to the party benefiting, so the corporate, let's call it, that's benefiting. But this new amendment to PRECCA has really just crystallized it and made it an actual offence, not just something that could be imputed to the company at the top.
Yeah.
So this is now making it an offence for the company that fails to put in adequate procedures. They're termed adequate procedures to prevent someone else acting on their behalf from doing something that helps them secure an unfair advantage, or if they act corruptly and I, as the company at the top, doesn't do anything to prevent them doing that. So processes in place that would say, you acting on my behalf, adhere to the standards that I set, and those are yet to be unpacked and defined under the Act. But that's the intention, is that it's to make it the onus on the corporate at the top that is ultimately benefiting from a contract or an arrangement or whatever it may be. They are the ones that have to, I guess, start at the top and say, if you want to work with me, you're required to make sure that you do all these things. And that's basically to mitigate the risk of corruption happening at a sort of down the chains, as it were.
Does it apply to this this newly inserted failure to prevent corruption offence in Section 34A of PRECCA? Does it also apply to, for example, if I'm a potential whistleblower and I stay silent?
No, so it wouldn't apply to a whistleblower. Certainly if the whistleblower was, say, a senior person within the organization that had knowledge that something was, that someone else was, say it was a joint venture partner of mine that I knew was, and I'm the corporate, that I knew was paying bribes to secure a contract that my company benefited from. And I failed to inform the company. That would be part of the company's procedures. So if the company did not have procedures that enabled a whistleblower to, safely report that up to the company, and they failed to take steps to prevent that happening, then yes, the company could face liability. But it's not the individual whistleblower themselves that would be the one at risk. It would be the company that failed to enable that and failed to take steps to make sure that there were procedures that enabled that that whistleblowing to come forward.
Right. So Section 34A also talks about what you just mentioned, procedures, the fact that companies need to have adequate procedures in place. Does the amended Act, go as far as to say what those adequate procedures would entail?
No. So the Act just says you have to have procedures in place. The Act, the amendment to the Act, is largely based on the Bribery Act in the UK, which has a similar, it's a failure to prevent offence, which I think our legislation has pretty much copied. And in that Act as well, the procedures aren't defined in the Act, but the Ministry of Justice in the UK has come out and set guidelines for what would be considered adequate procedures. And we anticipate that at some point in the future, our legislators will, either in the form of regulations or some other guidance, publish what they deem to be, and there won't be a one-size-fits-all approach, but it'll be a sort of list of, in the UK, they've got 6 procedures, adequate procedures that are set out. And our assumption in the sort of community is that a similar set of guidelines will be published as to what would constitute adequate procedures. And then it'll be taken on a case-by-case basis. If it's ever prosecuted, they will say, well, let's look at what procedures they actually had in place and see whether that measures up to what the enforcement authorities would deem adequate procedures.
And what about a sanction? What's the penalty here?
So the penalty is, again, not defined in the Act, specifically for this offence. So this offence is not, there's no penalty that's specifically ascribed to this offence. But the general, and it has not been tested because there's not been a lot of corruption prosecution, but the general offence, and it's a corporate, so it would be a corporate offence, so there'd be no imprisonment, but it would be a fine, and the limit for the fine is not specified in the Act. So it would be a fine for failing to prevent corruption taking place on the part of the corporate.
And what is your take on the amendments to the Act? Obviously, we've talked about the fact that corruption is such an important sticking point for many people going to the polls. It's also an important sticking point for us as a country financially. We talk about the issue of us being grey-listed, for example. We need to signal our intentions to take seriously this scourge of corruption that has such a grip on our country. But we're not lacking, as South Africa, in policy. It will, I imagine, depend on how it will be implemented.
Yeah, I think that's the nub of it, is that we actually don't have bad legislation when it comes to our AML, as you mentioned, from a grey-listing perspective, or our corruption legislation. In fact, predates the UK's Bribery Act, which is a 2010 Act. This is a 2004 Act that's just been amended. So we've had the mechanisms in place for quite some time, but it's just how that is implemented, how it's enforced, because otherwise it's really just as good as the paper that is written on. It needs to be enforced. There needs to be actual meaningful prosecution and implementation of our laws. Otherwise, they don't serve much use.
Yeah, they're not worth the paper they're written on, you could argue. Caomeron, let me thank you for your time this afternoon. Caomeron Dunstan-Smith is a partner at Herbert Smith Freehills. And Parliament amending South Africa's corruption legislation, creating a new offence of failing to prevent corruption. An important step, some might say.